Hello, I'm Thomas Hare, Chief Content Officer of the Performance Driven Marketing Institute, a not-for-profit trade association that serves companies in the performance and direct-to-consumer marketing world. Welcome to the first event in our spring seminar series created by the PDMI's Workshop Council, FTC Priorities and Practical Fixes, What Should Keep You Up at Night. We welcome all of you to today's event, PDMI members and non-members alike. Speaking of membership, if you're not a PDMI member but are attending today, we'd love to have you consider joining. During the past 13 months, when we've lost 3 multi-day in-person conventions, there's no better way to support the mission of the PDMI than joining and sharing your voice in the direction of the industry. In the handout tab of your control panel, you'll find our PDMI membership brochure. I urge you to download it, flip through it, and contact any of our team members should you desire more information. Before we get to today's conversation, one quick housekeeping note. The group will be addressing any questions from the audience at the end of today's session. You don't have to wait to ask them, however. Utilize the questions tab on your control panel to type and send your question in. We'll be collecting them and we'll try to get to as many as possible in the final moments of the webinar. Today, the PDMI's Workshop Council welcomes 2 incredible experts in the area of marketing regulation. Lesley Fair is a senior attorney with the Federal Trade Commission's Bureau of Consumer Protection. In 20 years as a litigator with the FTC's Division of Advertising Practices, she represented the Commission in numerous investigations into substantiation, continuity programs, advertising format, disclosures, and new marketing media. She now specializes in industry outreach and is the FTC's primary business blogger at business.ftc.gov. Fair teaches consumer protection law at George Washington University Law School and is a distinguished lecturer on the adjunct faculty of Catholic University's Columbus School of Law. Amy Mudge, co-leader of BakerHostetler's advertising, marketing, and digital media team, is a Chambers USA ranked regulatory lawyer. She routinely represents top-tier companies before the Federal Trade Commission, the National Advertising Division, and the Children's Advertising Review Unit, as well as in private, federal, and state class action defense, consumer protection, and antitrust litigation. From the nation's best-known food brands, major toy manufacturers, and health and wellness names, to digital media influencers, cutting-edge internet companies, and consumer product giants, the range of industries in which Mudge works reflects the strength of her leadership. Amy is also part of our PDMI Workshop Council. Thank you both for joining us today. We really appreciate it. Amy, take it away.
Thanks so much, Tom. And hello, everyone out in cyberspace. Sorry not to be with you in person at one of these super fun PDMI events, but really happy to have my dear friend Lesley Fair with us virtually or 2-dimensionally today. And there really is nobody better on the planet, and I'm not exaggerating, than Lesley to talk to you and to really distill what is going on at the FTC. Every time I hear Lesley speak, even though I spend most of my day appearing at the FTC, I learn something new. So I think this will be, and it's a fast drive-by, so buckle up your seatbelts. We're going to cover a lot of different topics today. One of the things, and many of you have heard me say this, even though the FTC has been, it's been a Trump FTC until very recently, it's been an FTC that acted like no Republicans I've ever met. It was one of the most, probably the most activist FTC in my 20 years of practice. And we certainly don't expect a Biden FTC when it is fully put into place to put the brakes or to do anything differently. So I think I know some of you always hear from the lawyers, oh, you gotta fear the FTC. Well, maybe we do always say that, but it really is. This is an incredibly activist, incredibly enforcement-minded agency, and I think they've also been as prolific as ever during the pandemic. If anything, I think enforcement has stepped up, and they really broadened the reach in terms of the number of cases they brought and the numbers of companies that they've targeted, including through formal enforcement and through massive warning letter campaigns. So we're going to talk a little bit about that today. But I think how we'd sort of set this up is Lesley's going to talk to you about some of the key cases and the things that the FTC has focused on and continues to focus on. And then I'll try to weigh in with, what does this mean for your business? What should you really think about? Because you've got a business to run and you've got to think about compliance. You've got to think about legal stuff, but you also have to set your priorities. And so that's a little bit of what we hope to do for you today. But I will turn it over to Lesley.
Thank you very much, Amy. Amy and I have boiled it down to sort of 10 basic topic areas that we think ought to be on your radar screen. You know, we call it what should keep you up at night. My hope is nothing, because my hope is that you are listening to your attorneys, you're listening to your conscience, and you're listening to your consumers. And that explains why truth in advertising isn't just the law, but it's very good business. You're getting the perspective of one staff person. I am not a political appointee. The FTC is an independent regulatory agency, and the screams you hear are from our 4 out of 5 commissioners, since we have one open seat, reminding me to remind you that you are hearing just my point of view. The next slide emphasizes what the large perspective the FTC has had in the past 13 months on health claims, especially COVID claims. The next slide shows one of the cases that the FTC has brought. And let me set this up. As Amy has mentioned, the FTC sent out at the early stages of the pandemic more than 350 warning letters saying to companies, we've been on your websites, we've looked on Instagram, we've looked at your Facebook and what you're saying, on Twitter, and we think you could be making deceptive representations about preventing, treating, or curing COVID. And we think you ought to be very careful about that. We sent those letters in the name of who I call the FTC, the Friendly Trade Commission, saying these are not lawsuits, these are warnings, and we hope in the next 3 days when we visit your website again, we will see these claims down. The good news is, generally speaking, that has happened. We are in litigation against a few companies that did not take that warning seriously. One example of a case that is just settled deals with the company Whole Leaf Organics that was making representations that a product called Thrive was going to, was clinically tested with proven ingredients to strengthen immune systems against pathogens like COVID-19. This company had received a warning letter from the FDA, not the FTC, but the FDA. And when we went back and looked more closely, the company was making not just anti-COVID claims, but was making anti-cancer claims. So the FTC's lawsuit and settlement dealt with both of those. Let me warn you, there is a new statute in play. The COVID-19 Consumer Protection Act, Congress passed this just a few months ago. It makes it illegal to engage in a deceptive act or practice that is associated with the treatment, cure, prevention, mitigation, or diagnosis of COVID-19. It also includes civil penalties. We have our first case announced earlier this week, but I'm sure this is an issue that's of a lot of interest to your clients, Amy.
Yes, and the civil penalty piece is we're not going to get into it today, but I'm sure many of you've heard about the case that's at the Supreme Court right now, which looks at whether the FTC and the FTC Act permits the FTC to basically go right to court to get money in cases. If there's a law that has penalties attached, the FTC can always go right there, and the amount of penalties that can attach in these cases is shockingly high, over $40,000 per violation. What I want to, and I think I know most of the folks on the call, everybody on the call probably understands, don't say my product cures COVID. Although we're kind of coming out of this, and many of us are 1 shot in, maybe 2 shots in, the way Lesley and I now are. This is going to be with us for some time, and everybody is still really scared of this. Please do not think that you are safe if you just avoid the words COVID or coronavirus. Even any products that you make that talk about immunity support, even more general things about wellness are going to get looked at. And the NAD has also brought some cases involving, I would say, what many of us would think of were just standard structure function claims, supports a healthy immune system. Even claims like that need to have science behind them. So if you're selling any products that talk about immunity, that talk about wellness, and the flip side, anything that talks about killing critters, antibacterial claims, really good time to take a fresh look at your substantiation. And the last thing I'll say about this is if you end up getting a warning letter from the FTC, treat that as the gift that it is. It really is the opportunity to switch gears and get things right before more formal enforcement happens. So even though it doesn't have an official seal on it, even though there's no requirement, there's no subpoena attached to it, it truly is an opportunity to course correct. And I can assure you, if you do get one of these, the FTC will not forget. And they do keep watching companies to whom they send warning letters.
Mm-hmm. The next slide shows something else the FTC has continued to be interested in. I used to, I used to, in my long history of the FTC, call these ads targeting elderly consumers. Now that I am one, I use a different phrase, and you can take this hashtag boomer consumer. So that's my phrase now, rather than elderly consumer. These are claims targeting pain relief, arthritis, diabetes, cognition, a lot of the things of interest to consumers in that baby boomer demographic. The two ads more on the left, don't let the death enzyme speed you toward your grave. And then the guy who's throwing away the walker with 95% pain relief. We see those, we've always seen those. We will continue to see those until companies get the message that those are considered very high priority from the FTC standpoint. The ad on the right is slightly different. Yes, the FTC challenged the cognition representations that the company made, but that's not all. The FTC also challenged the unauthorized use of Wolf Blitzer and the late Dr. Stephen Hawking, basically saying that they were represented as having endorsed these products when they hadn't. The other issue that was of concern, and I say this as somebody who worked on the FTC's first infomercial case in 1988, is deceptive format. You'll notice the look of this, the FTC alleged, looked to be kind of like the CNN news feeds, especially with Wolf Blitzer, with the breaking news. That's just not allowed under the FTC Act. We'll talk a little bit more about that in a second, but I think these are unsubstantiated claims, deceptive endorsements, deceptive format, or things that, as Amy will talk about, you really want to watch out for.
Lesley, was that the Blue Blockers case?
That was the Blue Blockers case, yes.
Okay, whoever's listening on the call who remembers that and was a part of that gets to ask the first question at the end. Those are oldies but goodies, timeless enforcement actions. I don't have too much to add here. I would say, I mean, obviously the using, Stephen Hawking's and things like those raise all kinds of trademark and other issues as well, not just deceptive advertising issues. I think we know the lure of the clickbait is very, very strong. And you think, what's the harm? Once they move over to my website, they'll understand where they are. I promise I'll only say the things I'm allowed to say then, and that is that it's a deceptive door opener. Even though you're not letting someone literally in your front door, you're getting them to come to your website that way. The FTC takes this stuff really seriously, and I do think although tons of the enforcement, we only had that one case, but so much of their work has been focused on COVID type fraud. But it is like some of these things we've been telling you for a long time about the cognition claims, and that was a particular pet project of former Chairwoman Ramirez. But some of these things don't go away. The FTC is always going to look to protect, the elderly.
Hashtag
all right.
Okay. The next slide shows another area.
Any vulnerable population, the FTC is gonna take a very hard look at protecting.
The next slide talks about an area all America is talking about, and that's the increase in the marketing of CBD-related products. Now, the FTC has announced its first 6 proposed settlements. There are lots of interesting federal and state laws out there that Amy will talk more about. The FTC's concern is simply advertising substantiation. So anytime I hear advertisers say it's the Wild West out there, I have to remind them, no, it isn't, because there's a 105-year-old statute that requires that you have substantiation for your claims. Our first rollout of 6 cases, Operation CB Deceit, dealt with everything from COVID-19 claims to representations about overactive bladder. Anytime you are making a representation about what a CBD product or any other product can do to provide a health benefit, companies need scientific substantiation. That could be the highest level of randomized clinical testing. Amy?
I think you said it wrong. It's CBD seat. I like it. CBD seat. That's what I love. This is one of my favorite names. The FTC is always fantastic at puns, and I have to say, I think this is my favorite one from 2020. But once again, the FTC is again focused, as you might well expect, focused on these hardcore cure claims. But it's worth a reminder that at least right now, the FDA has not cleared in this country the ability to sell these products when you swallow them. So right now, where we see most of these CBD, it's in topicals and things that you rub on yourselves. But any kind of claim, even much more benign claims, not disease claims, need to be supported by competent and reliable scientific evidence. And there are a number of state laws requiring registration, requiring particular disclosures, requiring QR codes on products with a link to websites with some more information. So this is one of those dreaded areas where a lot of the requirements are, it's a patchwork quilt of state law based things. So if you are headed into this area, make sure you've got smart legal counsel that are tracking these emerging laws.
The next slide talks about substantiation in a non-health related context. This may be, as the next slide shows, something from safety claims or also money-making claims. I think this federal mogul motorsports case that came out last year didn't get the attention it deserved. It was about aftermarket brake pads, maybe not the most exciting. I'm a little bit of a gearhead, but maybe not the most exciting for a lot of other people. But the company was making claims that its brake pads would stop a truck, a car, or an SUV faster than its competitors. And you can see from the ad, if you look closely, we have quite literally a soccer mom there. On the left is her SUV. On the right is a jacked up SUV that has been involved in an accident. We said to the company, let's see your testing methodology. As required, they turned over what was an independent test. Well, that's interesting. But we also look at the protocol. And the industry standard test, our allegation was that the protocol did not accurately reflect real world consumer use for how they would brake. The industry standard test directs the driver to press down hard on the brake pedal to simulate how drivers like us would respond in the kind of emergency depicted in this ad. However, the test protocol that the respondent used in this case had drivers apply a constant and relatively light pressure before coming to a stop. And that was the test that they alleged substantiated that up to 50 feet sooner claim. But again, that's not what happens in a real world kind of setting. So the FTC was very clear, yes, good that you had a test, but the presence of a test isn't what counts. We're going to look at what the substantiation, what the protocol is behind it. The next slide shows sort of a similar issue involving a financial case. This is the SoFi. This is a lot of a big company in the fintech space that was advertising refinancing student loans saves on average $22,359. Now, I wasn't a math major, but my recollection of average is that you add up the number of things and you take that total and you divide by the number of things. That's where you came up with an average. Well, that's not the way SoFi defined average. SoFi's definition of average was in that fine print that you're looking at on the slide. And the FTC's allegation was that SoFi excluded certain transactions in its coming up with that very impressive $22,000 plus average savings, in a way that was more favorable to its own advertising claims. How do you talk to clients about this, Amy?
Oh, I've got lots to say about these two things. I think the first thing I want to say is, the FTC does not discriminate. SoFi is a major national advertiser. I think they've had Super Bowl ads. Sometimes
this ad was on the World Series, actually.
I think sometimes our industry feels like we're that the FTC picks on us. But the FTC is equal opportunity. They look at national advertising claims. They look at claims of new entrants in the marketplace. They can't go after everyone, so they do pick and they choose. But every year you are going to see a very broad spectrum of the size and sophistication of the marketers that they do go after. So I think this is a good one, and just to remember they don't just always pick on us. I think some key things from both of these cases is we always say when we look at claims, in the script or on the website, what is your substantiation? And having substantiation or having that science is really important, but it's not the end of the story. So you've got to go on and you've got to say first, does your support match the claim that you're making? There's got to be that puzzle-like fit. And I think as one of the other things that Lesley said that's really important is the testing has to be consumer relevant. Even if you have a benefit, but it's not shown in the way that consumers actually use the product, either directed to use your product or the way they practically use your product, it's not going to work. Or if the benefit is it's there, you can measure it, but it's so small, it's not going to be really noticeable or appreciated. Again, probably not something you can claim around. And something from the SoFi case, it's sometimes, you might want to benchmark against a more expensive product in the marketplace, a more established product in the marketplace, and say, our product does it better, faster, smarter. You can't compare your product's best day to the competition's worst day. There's really does have to be that apples to apples comparison when you're making your savings or any other kind of performance benefit promise.
As the next slide shows, there's a lot that's been going on at the FTC with regard to social media and consumer reviews. It's a very hot topic area for all of us. The next slide shows the FTC settlement with Devumi. The allegation in this case was that the company, in effect, sold, not even in effect, they sold fake followers to actors, athletes, motivational speakers, law firm partners, investment professionals, and others to increase their, influencer cred, if you will, on Twitter, YouTube, or LinkedIn. So, we've done a lot in this area, but I think this is something where, big brands, our concern certainly is not to use things like that, but there's also a business reason why I would like to think brand companies that are concerned about their reputation would salute and champion cases like this brought by the FTC. What do you think, Amy?
100%. This is one again where we say we're getting beat up by the FTC. Why do they pick on us? This is one where the victims of the fraud here were companies that are using social media influencers, and these influencers were buying. They didn't have influence. They might have had a little bit, but they were buying their influence to be able to get more money. You're going to pay more for people with 1 million followers versus 100 followers. So I think it's great government to go after protecting business as well. But it is just as a practical piece there. It is the Wild West in the influencer marketplace, and smart companies can easily be the victim of fraud. So take a hard look at how you're spending your money in this space, and make sure you have some thoughtful compliance infrastructure and the ability to terminate influencers if you do discover they've overplayed their influence.
The next slide shows another example that I think sends a lot of important messages. You, I'm sure, are familiar with the kind of high-end skincare line, Sunday Riley Modern Skincare. The allegation in this case was that Sunday Riley, the company president, directed her staff members, and here is a quote from an email, to basically go on Sephora.com, the very well-established cosmetic and personal care online retailer, and gave step-by-step instructions on how to post, in effect, fake reviews. create a new persona, choose a different name, city, skin type, set up a, kind of a fake throwaway email address, clear your cookie history, and then use a VPN so they can't be detected. And these were instructions given by the CEO to her staff. The basic premise in this case is that if there is a material connection between an advertiser and an influencer, which could be a reviewer, a tweeter, an Instagrammer, a blogger, that consumers wouldn't expect, maybe a financial relationship, a family relationship, disclose it. And a lot of people are asking about, why is that? But think about it. If you went to a website and you saw, listings of best lawyers in Washington, D.C., and it listed Amy Mudge, not out of the picture, but would it be important to you to know that Amy Mudge's delightful mother had posted that, review? My guess is that would be material information that you'd want to know about. Now, the question about how to disclose, I'm always asked, what's the, what kind of code of federal regulations do I have to just, no, it's just, if Amy's mom wants to say, so proud of my daughter, Amy, who's doing great things as an attorney in Washington, I think she's the greatest, there's no problem. Because it has been done, that disclosure has been disclosed in a very organic way. And so our suggestion from cases like this, the FTC has some suggestions about how it can be done with hashtags, with simple language, no fancy legal mumbo jumbo required. Just disclose. That's really all that's required in these kinds of cases. I don't know if your mom has that website, Amy, but she might want to think about that for the future.
Suzanne is one proud mama. She is, although she's not super internet savvy, so I'm not sure if she could get the star listing right. But look, there's lots. I will tell you, I mean, when you look at the allegations in Sunday Riley, I think everybody in the call is going to say, I never do that. I never instruct my employees to create fake profiles and lie about us. I mean, this does smack of hardcore fraud. What I understand what's going on here behind the scenes is that this CEO thought that competitors were posting fake reviews, negative reviews about products on Sephora. So really felt that this was doing this as a as kind of a self-protection response. And unfortunately, bad behavior does not beget bad behavior. There are ways, if you think that there are fake reviews written about your products by competitors, that you can try to deal with them in a more lawful manner. I think what I want to tell this audience is reviews are really top of the FTC's mind. They brought it in any substantiation case. They're gonna probe into reviews, and we see a lot of counts or a lot of facts alleged. In a case like a health case where maybe the claims aren't supported, there usually is also and the mama and the aunt and the CEO's wife posted some reviews as well. But now is a good time to take a look at your practices around organic reviews that are posted on your own websites, not just on a third party like a Sephora or an Amazon. Look at how you are moderating reviews that come into your own site. Look what you're choosing to post. The FTC, and you can find a closing letter involving a company called Yotpo. They really looked and they said, we're concerned about companies that are looking at reviews and choosing not to post the 1, 2, and 3 star and choosing to only post the 4 and 5 star reviews. I think there's a lot of really good, legitimate, upstanding companies that would say, well, it's my website. I get to choose what to post. I've never committed or promised that I'm posting all reviews. And the FTC's view on this is, well, if you're posting an average star rating, you have, because the promise or the implied claim when you post an average star rating is that that's an aggregate of all the reviews you've received about the product. So this is looking into my crystal ball. We are going to see cases that are focused solely on reviews. They're not only going to be cases like the extreme cases, like some might say the Sunday Riley cases. So just take a look at your review practices and get some advice as to whether as to whether there's some tweaking that needs to be done.
I think the next slide is just a reminder of a statute that was passed in 2016. It was passed in December 2016, and it was passed unanimously by Congress. Go back in the DeLorean to remember what was going on in December 2016, right after that election, and Congress passed this statute unanimously. It's the Consumer Review Fairness Act. It makes it illegal for a company to use contract provisions that restrict a person's ability to review a company's products, services, or conduct, or if it imposes a penalty or fee against someone who gives a review. What you're seeing on the screen was one of the FTC's first cases. This was a Las Vegas trail ride, after being in the casino for a number of hours. What a nice idea, going out on a horse and kind of hitting the trails in Las Vegas for a little fresh air. But if you'll notice what was going on, buried in the company's licensing agreement, their end user, their consumer agreement, was a confidentiality non-disparagement provision that basically said that if the consumer is spotting that the animals are in any way abused or mistreated, and if they contact animal control or some other kind of animal protection organization, they will be charged a minimum of $5,000 in damages for reporting animal cruelty or animal neglect. What? I think this is the kind of thing the FTC brought a number of cases. Some of them were dealing with vacation rentals, some with things like HVAC companies, apartment management companies that basically had terms and conditions like this. One of the cases, the company actually did follow up on its threat and sued consumers who posted below anything other than a 5-star review. So I think this is something that I'm sure Amy is suggesting that her clients take a careful look at.
Well, this is also one, and I have to say, in hanging out with, it's not legal, but I've read a fair amount that consumers they're savvy. They do not trust. If they see a website with only 5-star reviews, they immediately think these are fake. And there's a lot more credibility given to companies that post all the reviews, including the negative ones, and then respond to them to say, we're so sorry you felt this way. We're so sorry you didn't like your horse in Las Vegas. We'll instant message you with a coupon, something like that later, if other consumers read, they say, hey, wait a minute, we get that companies aren't always going to hit it out of the park, but this is a company that cares about what its consumers think, and tries to do things right. So I think that's, again, not legal advice, but just some business things to think of. But assuming you're not going to, you're not going to be the kind of company that's literally going to threaten people that write bad reviews, where we can see provisions like this is in kind of sloppy cutting and pasting. So some of the terms and conditions on your website are things that that you borrowed from somewhere else and didn't take a look at all the blah blah blah. It's a good time to do that. If you've got terms and conditions on your website that you haven't looked at in a while, everybody's had to update their privacy policies, but some of the plain vanilla terms and conditions have been up there for a long time. And these types of provisions that you see an example of here can be lurking in the fine print that you may never look at. And even if you say, well, I've never enforced it and I have no intention to enforce it, just having these provisions is against the law. So good time to take.
Yeah. The next area that the FTC has continued to look at for many years is now it's called native advertising, but as the next slide shows, it's really been around, for years and years. Amy and I touched upon it briefly in talking about that Stephen Hawking Wolf Blitzer case. But here's just an example. The FTC challenged the company's pain relief claims for a device that claimed to, be able to treat, muscle or joint pain but that was only part of the ad campaign. The other part was this that appeared in something called Texas. I can't read. It was basically a magazine. I don't remember the exact name of Texas Lifestyle magazine, I think is what it was. And this appeared to be an article by a physician on a very interesting topic, gender gap in sports injuries and treatments. Fascinating topic. Well, what this was, though, was paid for content, for the company's device. Are advertisers allowed to be creative? Of course they are. But consumers have a right to know if what they're looking at is an ad or independent content, because that, to many consumers, is a very material consideration. And so again, are you allowed to be creative in format? You bet. But it is important that consumers are able to tell when what they're looking at is an ad. Amy?
Yeah, and look, content is king. Everybody needs to drive eyeballs to content, and doing things in an interesting way that's not just shameless advertising is really important. I think when this stuff first started coming out, people thought that it's going to be the death knell to label something as sponsored. And it just hasn't. Consumers really have understood that advertisers can create interesting content that can be engaging. But it needs to have that legend. We've got the old advertorial. I mean, calling something advertising always works, but it's not the only option. When the FTC put out some guidance on this a few years ago, they kind of reserved judgment for sponsored as to whether that was an ambiguous term. That really has emerged as the convention. And I would suggest, I think it's very unlikely the FTC is going to go after a company who clearly labels content as sponsored or promoted by or brought to you by, as long as that's done in a clear and conspicuous way. So you want to have that legend right at the top. You want to have it. You don't want to have it at the end. You want to have it, with the byline at the top. And you want to have it something that the eye is drawn to see. The other piece here is it's not just identifying the content as to make it clear that it is commercial content, but what you say about the products in the content, it is advertising, and you're going to be held to the same substantiation requirements that you would be in a direct ad. And especially if you hire a third party to write content for you, make sure they understand. You don't have to write the content for them, but give them a list of approved claims, give them a list of do's and don'ts to help guide what they write, to make sure that something somebody else says about your products isn't going to get you in trouble.
The next topic is one of interest to all kinds of marketers. This is ROSCA, the Restore Online Shoppers Confidence Act, and various forms of automatic shipments, continuity programs. There are a lot of different words that are used. The next slide shows a recent FTC case against a company that sold a product called ABC Mouse. This was kind of learning, kind of online learning software games, if you will, for kids. Yes, the FTC, challenged poorly disclosed terms of the auto renewal feature. This is hardly the first time that the FTC has brought this case. But I think this also points out another interesting aspect of ROSCA. ROSCA requires that companies must provide, and I'm quoting here, simple mechanisms to stop recurring charges. Unquote. That's not me talking, that's Congress talking. Simple mechanisms to stop recurring charges. The FTC alleged in this case that more than 100,000 exasperated consumers tried to cancel through the Contact Us link on ABC Mouse's customer support page. And rather than honoring those cancellations, instead the company said, nope, you can't cancel this way. Quote, a member's account can only be canceled by that member on the site itself, not via email or any other means. My feeling is you're looking for an easy way to exasperate 100,000 consumers who are attempting to cancel. It's not only violative of ROSCA, but it just is a red flag in consumers' faces. And remember, that poorly disclosed terms of auto renewals or auto renewals that, when consumers' requests for cancellation are not honored, that means that companies have charged their credit cards without authorization. That is a very risky policy, a very risky strategy, not just from an FTC standpoint, but from a lot of other federal agencies too. So you need to be very careful to make sure that you are dealing with ROSCA in and of itself. As the next slide shows, this is going to be a continuing topic that the FTC is going to be tackling April 29th. In just a few days, the FTC is sponsoring an online workshop. You can participate virtually, called Bringing Dark Patterns to Light, an FTC workshop. This is an area of a lot of concern, a lot of interest. I will tell you, the final agenda was just released. 2 members of Congress, a senator and a congresswoman, will be speaking at this event. I'm just saying that this is an issue that has attracted a lot of interest. I'm sure from many of your clients too, Amy.
Lesley, you should trademark that phrase. It's not a webinar until I hear Lesley saying, I'm not saying, I'm just saying.
Just saying.
Les, I want to dark patterns. Woo, that sounds spooky and interesting. Les, tell us what that means. How is that term being used? And I kind of think everything's old is new again. But what is the focus of the workshop?
The phrase dark patterns is relatively new, but I think it's talking about especially web design, app design that may lead consumers to be involved in certain transactions without their express authorization. So yes, the phrase is new or new-ish, but I think, Amy, it covers an awful lot of these undisclosed free-to-pay conversions, undisclosed continuity plans. I think it's been picked up with this new phrase, but I do think the FTC has 60 years of precedent on this topic.
Mm-hmm. It's a sexy name, and it's following new maybe some new ways of deceiving consumers, but I think it's going to be really interesting. But dark patterns really is another word for don't mislead people. Make sure your disclosures on the web are clear and conspicuous and easily noticeable, designed to draw the eye to them. But on ROSCA, the only thing, this industry is no stranger to subscription programs. And look, the FTC has been challenging negative option programs for many years under Section 5. When Congress passed ROSCA, it gave the FTC in the states those penalty powers right away, so you can get money right off the bat. And it gave a little bit of specificity with things like a requirement there's a simple means of canceling. And we thought that was kind of as bad as it was going to get. No, this is another one where there is an emerging patchwork quilt of state laws that amplify and add on to ROSCA. And so things like simple means of cancellation. Well, California's law requires an online method. All right. So having that, and there's a whole bunch of other nuances and things you need to know in individual states. So even if you looked at and got your subscription program ROSCA compliant when it came out a couple of years ago, it's a good time to have some refresh again to make sure that you're complying with the state laws, or maybe just decide to not offer those subscriptions in certain states where the requirements are just too onerous to be met. The one thing I'll remind you is no pre-check boxes. That's another, and we saw the box there to agree to the cancellation. Pre-check boxes in this space are really a no-no and a very bad idea. And the last thing that I'll say about this is I said in the beginning that getting warning letters from FTCs are gifts. I don't see everybody's faces, but I'm sure there was some eye rolling over that. I'm going to tell you, consumer complaints are gifts. The fact that the ABC Mouse case probably came about, at least in part, because of how many consumer complaints came in. If consumers are complaining to the FTC or the state AGs or the BBBs, that goes into this database, the Sentinel database that the FTC looks at. And they don't bring a case over, complaints here and there, but when they see emerging patterns, they sure do. And people don't complain to the FTC or the BBB right out of the bat. They typically go to the marketer to complain first. So if you're hearing a lot of the same complaints from your customers and you're ignoring them, you do that to your peril. Treat those as a gift, get ahead of them, because if you satisfy those customers, make changes to how you're doing things so you don't get more of these repeat complaints, chances are good you're going to be able to stay away from the FTC's enforcement lens.
The next topic is a big one because it's so highly material consumers. As the next slide shows, Made in the USA has been a major area of FTC interest and concern. The standard is this: Made in USA means that, quote, all or virtually all of the product has been made in America. That is, all significant parts, processing, labor that go into the product must be of US origin, and the product should not contain any or should contain only negligible foreign content. In a global marketplace, is that a high standard? You bet it is, no question. But one of the big things is just how material a representation this is to consumers. Deceptive Made in USA representations really, you can just read consumer complaints in this area. They take this very personally and feel very deceived and cheated when they find out that a company's claims about Made in USA don't live up to that standard. On the screen now, you're seeing a label for a Williams-Sonoma. I think it was a bedding product. I think it was a comforter of some kind. You'll see Made in China on the label. Well, the packaging that it came in said Made in USA. So the initial marketing said Made in USA. Of course, consumers opened it up, saw Made in China, not happy about that. This is an example where the FTC closed its investigation with a public closing letter to Williams-Sonoma, where Williams-Sonoma had represented, listen, we have a very robust program to make sure this doesn't happen. This was a one-time glitch. In an exercise of prosecutorial discretion, the FTC issued a closing letter but did not sue Williams-Sonoma. About a year passed. Take a look at the next slide. And these were representations for their bakeware, their Pottery Barn teen line, other things like that for furniture, cookware, made representations about made in America, made in the United States. In this case, again, we sued and alleged that a substantial portion was not made in USA. That case ultimately settled. It resulted in a $1 million financial judgment. Let me make it clear, it's important to know what percentage of that $1 million goes to the Federal Trade Commission. We want to be transparent about this. The percentage that goes to the FTC is zero. Bupkis, nada, not one red cent. In certain instances, anytime we can get the money back to consumers, that's certainly what we try to do. For certain things, civil penalties, they are required by statute to go to the United States Treasury. I just want to make it real clear, the one place they don't go is to the FTC. This is, the Made in USA area is a topic of an ongoing regulatory review. We routinely, every 10 years or even less than that, go back and look at our standards and say, is this still relevant in this marketplace? We accept all kinds of comment from businesses and consumers. We have workshops, we talk about this. There is ongoing regulatory review, but I will say, if you can take a look at the kinds of comments people have posted on this, deceptive Made in USA comments really get their goat. How do you counsel clients about this, Amy?
Yeah, people do really take this to heart, and there is some rulemaking now. So this is one we'll see if the FTC's long-standing guidance in this area converts to a rule, then there will be penalties right outside the box for violations. What I tell you here is as Lesley said, the FTC standard for how to substantiate a Made in USA, Made in America claim is very, very high. I don't want to say it's impossible, but it's really hard to substantiate a claim. But there's a lot of other things you can say if you do some of your manufacturing in the US. Qualified claims. I used to hear clients all the time say, if I can't say Made in USA, I'm not going to say anything at all. I think the tide is really turned on that because there is such a pride in American manufacture and an importance in supporting American workers. So if you do things like assemble in the USA, or I mean, the iPhone's a great example. Like, what do they? Those phones come from China. They say designed in the USA. There's a lot of thought power that comes out of Silicon Valley. So if there's pieces that you do in the U.S., there's a lot of qualified claims that aren't muddled and riddled with legalese. So if you want to figure out a middle ground that's a little bit safer that you can probably support, another great one to talk to your lawyers about. We've got a lot of creative ideas for you.
The second topic we want to mention is the mail order rule. It has a much longer name now, but it is if there is a comeback of the year award, it is to the 46-year-old mail order rule. The next slide shows how it has become really front and center in the time of COVID. You all remember what life was like about 8 or 9 months ago when I was still making masks out of bandanas and scrunchies. We were all clamoring to get the disinfecting products we needed, the PPE we needed. So there was real concern about this. So this is just one of many cases that the FTC brought. The company, just to show I appreciate irony like anybody else, supergooddeals.com, well, maybe not the best choice of company name. The FTC alleged that they were claiming to have those 3M respirator masks that people were clamoring for, and that consumers, as well as doctors' offices, dentists, daycare centers, home healthcare providers for the elderly, were clamoring to get this stuff. And the company was claiming pay today, ship tomorrow, going fast. Let's look at what the mail order rule requires of companies. Company must have a reasonable basis to expect that it will be able to ship within the time it states, in this case, ships tomorrow, or if no time is stated, within 30 days. Now, it's a practical rule. It is a rule that understands that glitch happens, especially now in times of global supply chain disruptions due to COVID. It's understandable. So not being able to honor that ships tomorrow promise is not catastrophic. One key provision of the rule is you can let your customers know, I know we said we'd ship tomorrow, we're experiencing a supply delay. You have an option, you can either agree to a delay in shipment or we'll cancel and we'll give you a prompt refund. It's easy to correct when there's a problem. The FTC's allegation in this case was that the company made these claims and without a reasonable basis and was not fulfilling their claims about shipment and was not honoring the mail order rule. Let me just mention, yes, there is a pending FTC action, but the company owner, Mr. Kevin Lipsitz, is also allegedly, lied to consumers in a way that has led to his indictment on federal charges by the United States Attorney in New York, in one of the districts in New York. So this is an example that didn't just deal with a civil matter. The company president is under criminal indictment as a result. But let me make it clear, this can happen. These mail order issues can happen to established, well-known consumer products companies, as the next slide shows. Fashion Nova, this was the FTC's complaint. It was a popular online fashion retailer. The FTC alleged that the company failed to ship in a timely manner and illegally issued gift cards in place of refunds, resulting in a $9.3 million civil penalty, the largest ever in a mail order rule case. The facts obviously substantially different from the PPE cases, but both covered under the mail order rule. What do you tell clients about this, Amy?
I think this is a really easy rule to comply with. I mean, 30 days, when this thing was written, 30 days might have seemed reasonable. 30 days is a lifetime. If I don't get my stuff in 2 days, I'm irked now. So I think it is a very, very livable rule. It's a very flexible rule. As Lesley said, if you're running late, just let people know. And you can say, we'll continue to ship unless you tell us not to. So it's a very advertiser and marketer friendly rule. Its provisions They've been around for a very long time, not difficult to comply with. Obviously, if you do have to give a refund, give cash back, no gift cards. But the rule is simple. It's very accessible. This is one, you probably don't even need to talk to your lawyer about it. This is one the FTC's got great information on their website if you have any questions about your mail order compliance.
The 8th issue that we want to touch on very briefly is lead generation. The next slide is an example of a case the FTC has brought. ArmyEnlist.com, U.S. Army information request, where a lot of folks that were interested perhaps in enlisting in the military could turn in information, find out about active duty, reserves. This case, I'm an Army brat. I'm one of those 12 schools in 12 years kind of kids. I have great respect for people who serve in the military. Well, this had nothing to do with recruitment for the military. This was a way to get leads of people of a certain age who might be interested actually in for-profit schooling. So there was no connection to the Department of Defense, no connection to the Army, any other branch of the military. So the FTC certainly sued Sunkey Publishing, who was the company involved in placing this online that was, we allege, claiming to have a Department of Defense or Army Reserves or military connection and had nothing to do with the Army. What they were doing with that very useful information was selling it to companies. In one instance, the FTC's lawsuit against CEC, this was a settlement with the operators of Colorado Technical University and American Intercontinental University. They settled charges that it used these deceptive leads to market its schools to consumers, resulting in a $30 million settlement. So as I'm sure Amy is going to say, you need to find out where those leads are generated. Amy?
Yeah, I think in the interest of time, I'll just say lead gen continues to be, and the FTC's going, they view it as, it takes a village here and everybody's responsible. So how the lead generators are generating those leads, and then the marketers that are buying those leads, everybody has a role in compliance. Everybody's got responsibility. So pointing the finger at somebody else, I didn't know they did it, is not going to win the day. The Division of Marketing Practices will, treats everybody as having an important compliance role in this ecosystem.
Just to finish up on a very hot topic, consumer privacy, as the next slide shows. And as you'll see from the next slide, the one place you don't want to be is on my logo slide that I show regularly. But big companies, small companies, apps. The big important message is to be transparent about your product, your practices, and don't assume consumers' personal information is yours to use or sell or transfer as you see fit. The next case, the next slide shows an example, a pretty shocking example. This was an app that women were using to track their fertility, to track their menstrual cycles. And my gosh, what more highly confidential information is there? And the company, of course, was very clear, we don't share this, when in fact, behind the scenes, the information was getting shared. What's going on behind the scenes in apps is something you need to be really concerned with. As I'm sure Amy will mention, California and Virginia have statutes you need to be concerned about. And I will tell you that yesterday, the 4 FTC commissioners were appearing before Congress, testifying there, and there was a lot of discussion from members of Congress about whether federal action in this area is necessary. So it's something, as Amy will tell you, you're going to want to be paying attention to.
Yeah, and again, this is one where, not that the FTC is not relevant, the FTC, I think, is done without a federal privacy statute, has been prolific and zealous in protecting consumers' data, looking to a privacy policy as a piece of advertisement, as claims, as promises, and holding companies to the commitments they make in the privacy policy. And then on the data security front, to hold companies to make sure they have a baseline of security, and if not, it's just simply unfair. So I have to say, I think with very little, Manisha Mithal's division of privacy and consumer and data protection has done extraordinary things. The states, though, this is another. It's a patchwork quilt. You got to see. Probably everybody in the call's updated its privacy policy for CCPA, is looking at CPRA. Just when you get that done, you know, other states are going to kick in. We'll all be wishing for federal privacy statute, so there's some preemption over this. But yeah, in the meantime, this is, you know, there's nothing more important than how do you collect the data, how do you use the data, and how do you secure the data.
We want to get to your questions, but let me just end with our number 10 issue, which is financial deception. Let me give you the 25 words or less on the next slide. The FTC's lawsuit against Progressive Leasing alleged that the rent-to-own payment plan company, alleged same as cash promises, and yet charged consumers, many of them low-income consumers, almost twice the retail price, resulting in $175 million back to consumers in a case like this. The final slide dealing with the case is the next one, Amazon. It's our first case dealing with the gig economy. The company made the representation that a lot of us, especially during COVID, have seen. 100% of tips are passed on to your courier, but the FTC alleged that Amazon pocketed about a third of those tips, keeping them from the hardworking men and women who are getting us our groceries, getting us our cleaning supplies, resulting in a proposed settlement of $61 million back to drivers. So the last slide explains how to get a hold of us, but I'm hoping we've left enough time for some questions.
And I don't know if I know we're a little bit over time. If there's any, Tom, we're happy to take them. I think in the financial deception, those are some novel cases. You know, in our industry, certainly the coaching and mentoring continues to be, a focus, and a whole industry that's looked at quite closely by Lois Greisman's excellent team in the Division of Marketing Practices, and we continue to see cases in that area of some overhyped earning claims. So that's here to stay. That's not going anywhere.
And wonderful stuff from both of you. Really great. I mean, you touched on just about anything and everything we could fathom here. Do have some interesting questions, and you know we're happy to go over a little bit just to attack maybe two or three of them. First one reaches back to the native advertising portion of this. Are there different rules or language that must be used when disclosing native versus independent content, depending on media channel, such as TV, mobile, social media? And do these rules or language requirements differ at all state by state?
So if it's, and I want to make sure I understand the question. If it's independent content, it doesn't need to be identified as native advertising. If it's true, it's editorial content, independent content. The New York Times or any blogger chooses to write about a product, and they're not paid to do it. There's no connection with the marketer. That no disclosure is necessary. Maybe we're getting to a place, and you see this now, where some people say, not sponsored. I'm not paid to write this. It's all my independent views, but those are not required disclosures. There's no state requirements that I'm aware of yet. Maybe we'll begin to see them. And this is not a law. This is the FTC's got native advertising guidelines that you can look at for sort of their views on this. And there's a lot of flexibility. Advertorial works, it's not required. Sponsored, again, Lesley will tell you the FTC says that is ambiguous. I will tell you, I think it is a comfortable phrase to use. Promoted by, I think, as well. Brought to you by is a little bit ambiguous. There's a question as to whether that implies the advertiser was not involved at all in the content, but merely paid for the placement. So what I tell you is no state laws, no federal law. It's all about guidance and good judgment. And I would tell you the most important thing is to make sure whatever word you're using is right up front, easy to see, easily recognizable. I think if you get that done, you can comfortably have a little bit of more flexibility over the words you choose. But I'm happy. If I didn't get to the heart of your question, please send me an email, reach out to me directly. I love talking about this stuff.
Social media is the next topic. Using social media influencers can seem like a risky move unless you have all your ducks in a row. Is there a checklist existing somewhere where all the things a marketer needs to do when making a deal with an influencer? Basically, I think they're asking if there's a checklist that they can access somewhere before they start going down this path.
Yeah, reach out to me again. We've got lots of presentations on this. I've got sort of things to think about when you're contracting or engaging with them. And yes, I'd go for the next hour. We could do a whole presentation on that. If you're interested, let Tom know, and we'll put something. The workshop committee will put something. Council will put something together. But yes, I have a checklist. I'm happy to share.
The only thing I would add is that compliance is a two-lane highway. And certainly influencers have legal responsibilities, and advertisers have legal responsibilities to be watching what influencers are doing on their behalf. And the FTC has brought cases, involving all sides of that equation. And so the one thing you can't do is contract away legal liability under the FTC Act. So if you are using influencers, that's perfectly fine. Just make sure to watch what they're doing on your behalf. And if they're straying and not paying attention to you, cut them loose.
Lesley, can you say which two members of Congress will be appearing at the upcoming workshop?
I do know Senator Warner is going to be appearing, and I am forgetting the name of the Congresswoman, and I am very embarrassed that I am forgetting the name of the Congresswoman, but I can say it is Senator Mark Warner of Virginia on the Senate side.
Great. Good to know. And I'm sure anyone can go to the FTC site and find out more information at any time.
And extend my apologies for not remembering the answer to that. Thank you.
We might have to apologize to the member of Congress more than anything. And then I guess we'll close out with something that's a little on the edgier side, and I might not be able to be reached. But is there a certain size of spend or scope, volume of sales that a campaign must reach in order for it to be worthy of FTC scrutiny?
The answer is no. Certainly we are looking at what is going to cause harm to consumers. Sometimes that may be major national campaigns that inflict, a lot of financial injury across the board. Sometimes it may be smaller campaigns that inflict a lot of injury to a smaller number of people. I think a lot of times in some of the business and coaching ones, you may not be dealing with millions of customers, but you're dealing with people who have lost their life savings. And so we're concerned about that. However, we're also concerned, to deal with things as they're developing in the marketplace. Another purpose for our law enforcement is to provide guidance for to certainly challenge deception against that company, but to offer guidance to other members of the industry. And so, I think a lot of times when companies see, let's say, a competitor getting sued, the response is, whew, not us. Okay, that may be the first response, but the second response ought to be, let's go back and see what our processes and practices are and make sure we're not doing the same thing. So especially in newer technology or in newer advertising media, the FTC will often take a careful look early on, to make sure that companies know that the standard legal practices still apply. And I'm looking at CBD as an example of that. Relatively new marketplace, but standard consumer protection principles apply. I don't know if you have anything to add to that, Amy.
I don't, other than to thank you for answering, because I think, enforcers might be like, I'm not answering that, because they don't want you, they don't want people to drive to if I heard 100,000, I'll always spend 99. Like it's not the, so I think it's, I'm a little bit of an apologist for my agency, but I will say, I think the way that the FTC engages with and will answer difficult questions is a testament to how well you interact with businesses. Because I will tell you, if any of you have to deal with some other agencies in Washington, it's not uniformly like that. So I want to thank you, Lesley, for your time, and I want to thank you with just how approachable you are, and will make your best efforts to answer all the questions you get.
We're a small agency, but we have always had an open door, open phone, open email policy. We cannot pre-clear companies' ads. You don't want us in that business. You don't want us writing your disclosures. They're not going to be what you want. But I think by engaging at events like this, engaging behind the scenes when you have concerns about, let's say, what a competitor might be up to, we try to offer that kind of open door policy. We also, and here's my plug for the FTC's business blog, I can guarantee you it is like no other blog, government blog you have read. We come out 2 or 3 times a week with 500-word, here's what you need to know guidance. The scary thing, as I said, is that I'm the blogger. I don't think I would give me access to my government agency's website, but they do. But we try to be as transparent as we possibly can to offer the kind of guidance that is helpful to companies like yours.
They're very well written. Leslie has no footnotes, no cites to cases. They're written, you wouldn't even know Leslie is a lawyer from how she writes. Leslie, what's the URL? I forget. We should have had it on here, and I'm sorry.
You can go to business.ftc.gov, and that offers all of our business guidance, including the blog. And I think I'm complimented that you say you can't tell I'm a lawyer. I think, but okay, I'll take it.
To be a compliment. It was.
Thanks.
It was.
Well,
All right.
yeah.
Back to you, Tom.
Yeah, thank you both so much. Really appreciate the openness. Thank you, Amy, for bringing the idea to the table as part of the workshop, agreeing to join us, and for just such great information and conversation between the two of you. We really appreciate it. If you are a PDMI member and would like to get involved in one of our councils, such as the Workshop Council, which brought you this event, please reach out to us. We're happy to add your voice. We always need more voices, and that's the goal of the association. Your next opportunity to attend a PDMI event live online is our next episode of Take 20, the 20-minute webinar series created by our Brand Response Council, speaking of our councils, which will air live next Wednesday, April 28th at 2 o'clock Eastern, 11 a.m. Pacific time. Please visit thepdmi.com/take-20 to check out the upcoming schedule and register to attend today. The next spring seminar series event, slated for mid to late May, will be announced soon. Please keep an eye on your email, our website, and our social media for more information and your chance to register. And one more time for Leslie's blog, business.ftc.gov. Thanks again for joining us today. Enjoy the rest of your day and the rest of your work week. Stay well. Bye-bye.
Thank you.